Yes, so welcome everybody. Thank you so much for joining this afternoon to this Kinship Week Scotland event. It's fantastic to see so many of you coming on Wednesday afternoon. Just a few things before I hand over to my colleague Rona to do introductions. If you are unfamiliar with this format of webinar, all that you will be able, well, you'll be relieved to know that you will not be on camera. Also, you will not be able to be heard either. So if you do have the zoo and the wildlife park in the background, don't worry about it. No one is going to be disturbed. That does mean, though, that if you hear a dog, it's probably mine and not yours. So please get in touch, though. It doesn't mean if you're not on screen and you can't be heard that you can't interact. If you do the wonderful mouse wiggle on your screen, depending on your device, there is a chat function at the bottom, which it would be absolutely fantastic for you to actually get in touch with and ask comments and pass remarks as the webinar is producing, going ahead. And also, more importantly, perhaps, if you do have any questions for the panel as the day goes on, there are already panelist questions submitted. Use the Q&A, please, and we will get to these towards the end of the session if we have time. I think it's right to say that if we do run out of time and we haven't got the ability to go through all of the Q&A, we will work, or the panel will work on them over time to actually get written responses that we can share anonymously to everybody. And that's the final thing that I would like to mention as well, is that any questions that do get put in the Q&A, I will ask them anonymously, so please don't be shy. And with no further ado, I will hand over to my colleague Rona Pollock, who works with me at the Kinship Care Advice Service Scotland, who will lead today's webinar. So over to you, Rona.
Thank you, Simon. Good afternoon, everybody. My name is Rona Pollock. I'm the legal consultant with Adoption and Fostering Alliance Scotland, but with Kinship Care Advisory Service Scotland. I'm joined today by two very experienced solicitors. Firstly, Claire Ann McFadden, who is a leading solicitor in Scotland for litigation in permanence and family child law. She's been a partner at J.K. Cameron Solicitors Glasgow since 2003. Carol Ann has acted for kinship carers during this time, offering advice, representation and appearing in court. She recognises the particular needs of kinship carers and the children that you care for, and is absolutely committed to providing informed and relevant legal support to her clients. One of the quotes about Claire Ann is that Claire Ann has established an enviable reputation in relation to her ability to identify the pertinent legal and factual issues in a case and to ensure expediency of time and cost. I'm also joined by Emma Letham, who is an associate with Wright Johnson and Mackenzie Solicitors, specialising in permanence care with a particular expertise in child welfare and child psychology. She too has dealt with numerous highly contested family cases in sheriff courts throughout Scotland. Emma understands the need for kinship carers to have tailored advice that meets their individual circumstances. Clients have described her as friendly and accessible, always taking time to explain and answer questions. She was also very thorough, organised and calm, even when events took unexpected turns. We couldn't have hoped for a better advisor and representative. I'm Rona Pollock, the legal consultant with the Kinship Care Advisory Service. I'm a qualified lawyer and I've lectured in child welfare law throughout Scotland, and I'm also a safeguarder appointed by the Sheriff Courts in children's hearings. I was a children's reporter for 20 years, and I've used that experience as well as in my current position to inform and influence Scottish Government policy. So just to say again, welcome to all of you. This has been a marvellous week so far, and the turnout and engagement has been superb. We recognise that this doesn't only last for a week, although it's Kinship Care Week Scotland, that it's your day-to-day lived experience of looking after the children who are in your care. Just to remind you that we are always here for you and pleased to make use of us through our helpline, which is 0808 800 0006. That will come up in the chat. What KCOs is here to do is to deliver the best possible support to kinship carers who play such a critical role in providing secure, stable and nurturing homes for children who can't be cared for by their parents. What we've done is provided fact sheets to help explain some of the legal terms, and you can find these on our website. Today isn't about that. It isn't about explaining these in any great detail, although we will touch on them. I want to make the most use that we have with Claire Ann and Emma, who are there to provide this absolutely unique opportunity to be able to give you advice in relation to the cases that, in relation to your own particular situations. So we are looking at individual questions. I'm going to just start now with the first question, which I am going to ask of Claire Ann. Claire Ann, why would the local authority go for a permanence order to place my nieces with me? Would it not be better for me to apply to the court for a kinship care order?
Both of those orders are permanence outcomes for children, and usually the social work department would take careful consideration of those two routes amongst other routes, and so they would devise a plan that they think is best to meet the needs of that child in consultation with the carers. And the questioner is quite right that it's important to scrutinise why one route and not the other, both ways around, because very often social work will go for and suggest care planning for kinship care orders, where in fact a permanence order would be much better. They might go for a permanence order because of certain factors, not to do with you as a carer, but to do with the birth family, whether it's your relative or the ex-partner of your child who is the parents of the child you have in your care, or whether it's a cousin or an auntie. There would be concerns sometimes that when it comes to a permanence order, there is a need for more scaffolding around the family to protect them perhaps from the rigours of conflict and of escalation of that conflict that can arise where you compare that to just a straightforward kinship care order. If you go for a kinship care order, then usually any compulsory supervision order, that's the involvement of the children's hearing, would end after you get a kinship care order. And that leaves the carer alone with the family dynamic, and that's fine if the parents aren't around or if you have a good relationship with the parents. But if you have a family dynamic where perhaps there's ongoing contact and it might be that there's hostility from the birth parents, then very often a permanence order is the preferred route to protect you, the carer, from being left entirely to deal with that set of circumstances on your own. It means that there's that support would be there long term. It does, of course, mean the children are still looked after children, which might be a designation that you don't want. You maybe don't want them to remain looked after. So it's important to have a conversation with the social work department. It may be that they understand that you don't want to go for kinship care orders. They've been operating on that basis, unawares that you do. So there's a whole range of reasons. It doesn't make it a bad thing to do. Usually it means more support for families rather than less. But it's about striking the right balance between you feeling enabled to parent and the local authority feeling they can give you that support.
Thanks very much for that, Claire Ann. Emma, I've got a question about, will I need to give evidence in court to get the kinship care order, and how long does that take, and what rights will I have if I do decide to apply for the kinship care order?
So this will depend on whether the order which you're looking for is contested or not. If the order is not contested, if the children's parents agree with you getting the kinship care order, then it's unlikely you would need to give evidence in court. However, if it is contested by the children's parents, then you might need to provide the court with evidence. This will be evidence as to why the order should be granted, and you'll be talking about what is in the children's or the child's best interests. These days, this kind of evidence is mainly given by way of what we call an affidavit. That's a legal term, but essentially just like a written statement. Your solicitor would take information from you, they would frame the affidavit, and you would get the chance to review it and make sure you were happy with it. Then you would notarise the affidavit. Again, as this is your evidence, you'll require to raise your right hand, take the oath and sign each page of the statement. Pre-coronavirus, this would normally be done in your solicitor's office, but at the moment it can be done virtually via Zoom. The affidavits They can be quite lengthy if they need to cover a lot of information, but the benefit of them is that it means that you don't need to spend as long in court in that witness box giving evidence. In this situation, you would only need to come to court if the solicitor for the child's parents wanted to ask you questions or put their client's position to you. You may have heard this term, it's called cross-examination. In terms of how long it takes, if the affidavit is prepared beforehand, you shouldn't be in the witness box for too long. It really just depends on how many questions the other solicitor wants to ask. I've seen some people spend half an hour to an hour being questioned, and then some can be a bit longer than that. But you can ask for comfort breaks and such like during, if you feel like you've been answering questions for a while and you simply need a short break. Sheriffs and the courts are relatively understanding in that respect. And in terms of the rights that you would have, the right to have the child, normally it's the residence order, so it'll be the child to live with you. There's all sorts of other rights that can follow that as well, such as applying for a passport to take the child out the country, consenting to medical, dental treatments, consent to educational, other support for the child. It really just depends, and that's something that you can speak to social work and speak to your solicitor about, what kind of things that you're looking for, if there needs to be specific things mentioned in the kinship care order when you're applying for it. And as I say, it all depends on your own circumstances in that respect.
Thanks for that. So is a kinship care order, is that individual to each? You're saying it's individual to each circumstance?
It can be. I would be asking exactly what they're looking for in that respect. If you can have a sort of general order, or you can have more specific parts to the order, depending on the person's background, circumstances, and what they feel they need in terms of their parental rights and from the court and responsibilities.
Mm-hmm. So it just depends what is going to be needed, and the main thing about the kinship care order is that the sheriff, when he's making a decision, has to make a decision that represents the best interest of the child. So while the kinship carers may have one perspective and the parents might have another, it's really up to the sheriff to decide what is going to be in the best interest of the child. It's the welfare of the child that's absolutely paramount. So once the kinship care order is made, circumstances change in people's lives, and sometimes something that worked previously isn't any longer as helpful or as relevant as it was before. And I've got a couple of questions here from grandparents. One's from a grandparent, and it is about the kinship care order. And what's happened here is that the carer's looking after her 14-year-old grandson who's disabled. The child came to live with the grandmother because the mother was neglecting the child. The carer has a kinship care order for the child. The court arranged 1 hour contact for the mother every month. However, the carer and the social worker are in agreement that this contact has to be removed because the meeting's not beneficial for the child. The carer is seeking legal advice on how to stop the contact as the mother doesn't interact with the child. Claire-Anne, what would be done in a circumstance like that, a situation like that, where the mother still wants the contact to continue and the grandmother feels that it's clearly not any longer in the best interest of the child? Would she have to just keep on going on with contact, or is there anything that can be done to vary that kinship care order?
Sure, there is things that can be done to vary it. That you don't have to proceed with a circumstance that you don't believe is any longer in the best interest of the child. And as you've said, circumstances change. And so it is possible under any kinship care order for the case to go back to a sheriff to look at it on the up-to-date circumstances, maybe 1 or 2 years later, and to vary the terms of the kinship care order. Either party can apply to do that. So that's either the carers who think the contact's not working, or a parent, a birth parent who's maybe not had any contact and thinks now's a good time for it to resume. But for this particular child who's 14 and the contact's not working, much of it will depend on the nature of the disability, because if this is a child who has any particular educational support needs, or maybe has any learning disability, then it might be more difficult to get that child's views. But with a child of 14 who didn't have such issues, then the child's views would be very, very important, because at aged 14, the court automatically deems that child old enough to be able to tell the court their views. There's an obligation now more than ever under improved legislation where children must be listened to about what they want. But their views are not determinative. Their views are just a big part of what's taken into account. And so what's also important is what the grandmother and what the social work department think is appropriate for this child. So regardless of a child's age, if it was a much younger child, then still the carer and the social work department's views would be very weighty for a sheriff about what's best in this child's interests. The first thing would be to write to the mother, rather than going straight back to court. What you would want to do is try and open a dialogue, either the carer and the mother direct, if there was a relationship, or social work with the mother, if there's a relationship there. The last resort is to go back to court. Very often, the best way to start is to discuss and inform the mum, because a lot of parents don't realise the impact, because they only see the child in the moment, and in the moment children normally function okay. It's the before and the after that tells the story, which is that child's not coping with the contact, or it's causing a lot of disruption elsewhere, at school or at home. And so sometimes it's as simple as telling the mother, and if you have a mother who can put the child's needs first, that mother may listen. If not, social work might have to step in a bit firmer, and ultimately though you do have that recourse to the sheriff court to go back and say, look, we've tried to have a dialogue, here's the situation, the mother's not taking it on board, so sheriff, will you please take into account what we've got, and will you change the order? And the sheriff will look at the matter again. There may be the need for some evidence again, but very often it's a round table discussion regarding that kind of matter that can resolve the situation. And so rather than having monthly face-to-face contact, the sheriff may reduce the frequency or may introduce indirect contact, something that's maybe more palatable for the child that he can manage, or maybe there's no contact at all. But there will be consideration of what everyone wants around that table. The sheriff will put the child's needs first, and if a 14-year-old is able to articulate their views, the sheriff will give a lot of weight to that about what the child wants.
Thanks, Claire-Anne. In terms of getting the views of the child, would the child be able to instruct their own solicitor, or would you use a child advocacy worker so that the child's views are communicated to the court? In your experience, what works better?
It either can work well. It depends on the circumstances. You have children who would rather deal in private, maybe in the privacy of their home or school, with giving their views over to an advocacy worker. But you have also other children who are quite assertive, quite resilient, and even from the age of 10, 11, are able to instruct their own solicitor to be involved directly in the case. That will just depend on that particular child's nature. By the age of 12 or 14, there's no obligation on the child to have a solicitor. The child doesn't even need to engage with the advocacy worker. Some children like to go direct to the court and have a meeting with the sheriff in private and tell the sheriff their views and say, this is what happens and this is why I don't want it. So there's a lot of flexibility for children to make sure that the fundamental right is observed, that we take their views in whatever way suits that child best, and that we have regard to those views.
Thanks, Claire-Anne. One of the big problems, and it's coming through the helpline and the questions that have been asked, is in terms of how to finance the court proceedings from the kinship carers' point of view. Emma, what does the local authority require to contribute? What's been your experience with local authorities? I know that it's inconsistent across the country, and some local authorities will contribute some of it, some will contribute all of it. But then when we're talking about coming back maybe a couple of years later, what can the kinship carers do to try and finance that? Or would it be better for them just to simply try and get the child to ask for a solicitor so that they are automatically entitled to legal aid?
Well, it's a couple of things Rona, in terms of tips essentially for kinship carers, I would always say from the outset to do the research and look for a lawyer who has experience in dealing with the kinship care orders. Might mention it on their website, or when you speak to the solicitor, don't be afraid to ask them what their experience is, because this is, I'll come back to that, because that helps with legal costs further down the line. Would always check if they are eligible for legal aid. The kinship carer should be able to ask the solicitors who deal with legal aid to let them know, to see if their circumstances would mean they're eligible. Failing which, then speak to the social work department, find out what financial assistance that they're going to provide. In my experience, the social work department have covered the cost of kinship care orders. I know it does vary across all the local authorities in terms of the assistance they're prepared to give. One thing I would ask the social work department, what financial assistance, not only if it's going to be agreement with the parents, but if any issues are going to be contested, what financial assistance they can give, and to get that in writing, just so that they've got all that information from the outset. And again, asking what if they do need to come back at a later date, speak to the social work department, find out where you're going to stand if it needs to be varied later down the line in that respect. I'm just going to see any other points. And then yes, if things do become contested, I would be saying to ask that either the kinship carers can or ask the social work department to request sort of regular updates in terms of the cost from the solicitors to help keep everyone updated and abreast of the cost, so that there's no surprises later down the line. You mentioned there, Rona, if the child, depending on what age the child is, that may be something that they want to take into account as well in terms of instructing a solicitor. So again, coming back to that, it does depend on each sort of everyone's individual circumstances, but certainly keep the social work department involved, find out what their stance is on it, and speak to a solicitor about the legal aid in the first instance, and then that allows them to make an informed decision going forward.
Thanks for that. Claire, and I've got an inquiry from a kinship carer whose grandchild was, actually the problem was that the mother has a drug addiction problem, and the grandparents stepped in before social work had a chance to even see that there was anything wrong, and they've been looking after this child for the last 3 years. Now, financially, it's really making life very difficult for them, and they've contacted social work, but they've been told that this child isn't an eligible child, and they can't really understand what the distinction is, because had they just left things to get really bad, then heaven knows what would have happened to the child. But because they stepped in, they feel as if they're being penalised for that. What is the situation in terms of what they might be entitled to? And I'm talking about kinship care support under the 2014 Children and Young People Scotland Act, when they're actually looking at what supports can be put in place in terms of housing and resources and access to CAMs and anything else that they might have. Why are they treated differently?
The reason is because when you look at that act, that piece of legislation that the Scottish Government brought in, that Children and Young People Act 2014, if you look at section 71 of that, it sets out that the local authority must assist people in relation to financial support and services. However, as you work your way through that part of the Act, there's some qualifying criteria. And when you get down to section 71.5, what it tells us is that it's only for an eligible child. And the Scottish Government defined the eligible child as a child who is at risk of being looked after by the local authority, a child at risk of being accommodated. Now, that child, because that child's in already a very settled and nurturing placement with those people who are asking this question, there is no risk of that child coming into care, so that child is not an eligible child. They're round the wrong way for the services to apply for them, because the way the Scottish Government have phrased the legislation, it's for those children who come in through the hands of social work and are placed with family members through social work intervention that are eligible children, and that's why they're treated differently. Now, that is one of the major problems, is that it's a very narrow qualifying criteria for kinship care allowances, which can include financial support for accommodation, legal fees for the kinship care order, and other financial supports that follow, or services such as CAMS. So if they're qualifying, then that's great, they're on that pathway. If, like this couple, are not qualifying, then that child is not recognised. And the problem they have with the local authority who they're asking for support is that the local authority look back at the legislation. The Scottish Government gives the local authority funding and direction based on that eligibility criteria. So the first thing the social work department at the local authority have to do is look at the criteria and say you don't qualify for this. Now, that is a subjective test, and that's another problem with it, but where it raises a wee bit of hope is that it's a question of interpretation by the social work department at the local authority. So therefore it's a discretionary test that the social work department are applying. And so what a couple in that situation would want to do would be to challenge the decision courteously and cooperatively and explain that, but for our early intervention to save this child coming into the care system, he may well have been in the care system. And that's the distinction, is that you've acted more responsibly and appear to be being penalised. So there has to be a request formally made in writing to the social work department to ask them to exercise their discretion differently, to recognise this child as a child who is at risk of coming into care, but for these carers who acted so promptly. Now, I would not want to give a high level of expectation that social work will simply turn around and say differently. What has to happen is the onus is on people in that situation to push hard, to ask the social work department to escalate the matter to the legal department and ask for a review of the decisions that have been made to exclude them from that eligibility criteria. Meanwhile, I know from your organisation, Rona, and from lots of other social work collaborative operations, that there's recognition this has to change. This is something that has to go back to the Scottish Parliament, and they have to amend in order to realise that there has to be a wider net here to catch these families, because their selective criteria at the Scottish Government isn't effective. So if your dialogue with the social work department doesn't prove fruitful, then you may also want to consider instructing a solicitor. The difficulty there is obvious, and that is that you're going to incur costs. Unless you qualify for legal aid, then you're going to have to pay a solicitor to take that forward. There are very good internal mechanisms within social work departments to make complaints, to raise criticisms, to seek for review without the need for a solicitor. Not that I'm trying to do Emma and I or anyone else out of work, but you've got to prioritise what you do with your funding when you're already struggling to be recognised for funding elsewhere. So it is sometimes about pushing back on the social work department and seeking that they look at this decision again.
Thanks for that, Clara, and that's really helpful. I mean, we had an event earlier on in the week, and it was the Minister for Children, Marie Todd, who was speaking at that and was questioned about this discrepancy in relation to kinship carers and the sort of means testing that sometimes comes into deciding what kinship carers are going to be eligible for, but also this definition of the eligible child, because the more responsible you are as a kinship carer, the more you can anticipate harm to the child, then the worse it is for you, because you don't let it happen. If you don't let it happen, then they can't be a looked after child. And she's given an undertaking to look at that and to consult and to try and work out a way of making this fairer. What she's saying is that local authorities each have their own budgets, and they decide how they're going to spend those budgets. And where they're going to direct that money. But what she did say was, if you're unhappy with a service that you're getting, and like Clara, I don't want to cause trouble, but she says you can always go to your MSP and bring it to their attention and say, look, in our individual situation, this is not fair, it's not working. But like Claire-Anne, I would say, please do try and work with social work, first and foremost, to see what you're eligible for, what they are willing to put in place, because ultimately these are children who are living within the local authority. Whether or not they were looked after or ever were looked after, they are still the responsibility of the local authority, because they have a child's plan for each of the 32 local authorities in Scotland. So it can be very, very frustrating. Emma, I've got a question here from a grandmother saying, why can't I just adopt? Would it not be better just to adopt my grandson than bother with a kinship care order or a permanence order or anything else, and then he's mine?
Well, it depends again on the circumstances. She might be in a position that she's able to adopt, but in terms of what's best for the grandson, it will depend on that particular circumstances. If it's a situation where his mum and dad, for whatever reason, agree for the grandmother to adopt, or for example, if they're sadly deceased, then adoption process might be the way forward in that situation. It'd be helpful for her to speak with the social workers, check whether they're supportive of her going ahead with an adoption, or whether some other process would be better. Because with adoption, the social workers will require to be supportive and prepare a report for the court as part of that process. In terms of, again, going forward, I would suggest that she speaks with a solicitor as well, someone that has experience of adoption, kinship care, permanence, and they can discuss all the different legal routes and what would be best for her particular situation. Another thing to think about with adoption is any ongoing contact between the child and the mum and dad. If this is to be part of the adoption order, if there's an agreement between the grandmother and the parents, what's that contact going to look like going forward, which days, how many hours, and as I say, if there's an agreement, then again, that would be a straightforward process. That things become more complicated when there's either no agreement in relation to the adoption order itself, or if there's an issue in agreeing what the post-adoption contact's to look like as well. It's, as I say, speaking about the different options for the kinship care permanence order, some of these, with the permanence order, that's where some of the local authority would take on the parental rights and responsibilities, and they'd be removed from the parents, but they could be shared with the grandmother, and if there's a grandfather on the scene as well. I would say that adoption's obviously considered a draconian measure, because it is removing all the parental rights and responsibilities from the parents. So if the parents don't consent and they aren't deceased, then you would need to provide evidence to the court. Can be quite a hard test to meet depending on the background circumstances. You may need to show that the parents that they're unable to discharge their parental rights and responsibilities at the moment, that they're unlikely to continue to be able to do so, and or that the welfare of the child requires the adoption order to be granted. So again, if it's not going to be agreed, you could be looking at a sort of longer court process. So you're best to take all the background information and speak with the social worker and speak with a solicitor, let them know everything that's going on, and they'll be able to advise you on all the different legal options that are open to you, so that you can make an informed decision going forward. Again, in terms of costs as well, if it's agreed, if it's going to be straightforward, then the costs are pretty similar between all the solicitors that are doing adoption work. But if it becomes contested, that's where things can change as well. So you really need to speak to the social work department, and again, find out what assistance that they're able to provide in respect if you're going to go ahead with an adoption and seeking an adoption order.
Thanks, Emma. I mean, what I hear from our kinship carers is that they really just want to make the right choice for the child. They don't want to go for adoption or go for a kinship care order if that means that social work aren't going to be there anymore to be able to help them, to be able to put in place the resources that the child might need, and that the child then, once they're adopted or in a kinship care order, just go to the back of the queue. So I think really what we're saying is it's terribly important beforehand for kinship carers to have an understanding, or to have it in writing with the social work department, what their kinship care policy is. So firstly, what the kinship care policy is and how that is going to work on a day-to-day basis moving forward with the child in their care. Because the last thing they want is to go for this private law application under the kinship care system, which then would leave them completely alone and without the local authority having any legal obligation to have to support them or to support the child. And that's what a lot of the kinship carers are worried about. You know, if I go for this kinship care order, does that then mean that there won't be that there won't be this backup? I've got another question that's just come in. What happens in terms of medical consent when both birth parent and kinship carers have the parental rights and responsibilities? And that'd be quite a common situation unless the sheriff had actually divested the parental rights and responsibilities from the parents in relation to that. But I imagine it would be the same as with two parents who've got parental rights and responsibilities. If one of them gives consent, then that's absolutely fine. But taking into account, and this is the thing that we always get wrapped up on, who's got the powers, etc. But it comes down to the child as well, because you won't have a medical practitioner carrying out any medical examination or anything, even in terms of dental work, where the child isn't giving their consent. So first and foremost, what we should be asking is about the consent of the child. But have either of you come across a situation where the medical consents have been shared and it's caused any kind of problem?
No, generally if it's been certified by the court that there is an order, then usually there isn't a problem. If you are a carer and obtain a kinship care order, then inherent in your residence order and your parental rights and responsibilities, which you've usually got both of, is your capacity to give consent, particularly to any emergency medical treatment. And in some cases, medics, if a child's not in your care, medics will continue to perform a medical procedure even without anyone's consent if it's an emergency. Planned can be a bit more difficult because sometimes medics ask for the parental consent and they put foster carers and kinship carers in an awkward position because the medics can give the impression that their actual parents' consent required. That's not the case. Again, kinship carers can give consent. The only time it becomes problematic is if you have a mum or a dad who still have their parental rights and don't believe that treatment should be given. Usually it's planned treatment, and it's usually treatment that in the short term can cause the child more pain and damage to organs or to limbs, but for a longer term benefit. Then sometimes you'll get birth parents who will want to exert their rights and say, I don't agree with that. The onus would then be on them to do something through the court system to interfere with that. Otherwise, if you're the carer who has residence and who has orders, then you're entitled to give consent and proceed with matters. You don't have to defer every time to the other parent. It's all proportionate to the level of involvement that that parent has in the child's life. If they have contact on a relatively infrequent basis, then it's not something that I would be advising my clients to pay any attention to, really, unless there was a good reason to involve the parent in the situation. Because day-to-day care requires you being able to ensure, just like you do with everything, that that aspect of the child's welfare is looked after. Same as sending him to school, same as deciding what his diet is. You have that ability to give medical consent.
Okay, thanks for that, Emma. Sorry, Claire-Anne. The other questions I have are in relation to children's hearings, and one is from an aunt who's looking after her niece. What can I expect at a children's hearing? Am I allowed to attend? Will my niece be expected to come along as well? And she is 6, and I've heard about something about being a relevant person. I think I am relevant, but somebody said it was a legal thing that I had to do. So in relation to children's hearings, quite often what will happen is the child will be, that's the way of securing the child's residence with you. So a children's hearing will put in place a compulsory supervision order, an interim compulsory supervision order where it's necessary. And that means it's suspending the parental rights and responsibilities in relation to where the child is living. And they can put a measure on that compulsory supervision order that names yours as a place of residence. In terms of whether or not you would be allowed to attend, then that's there is a legal test there, and the legal test about a relevant person is whether or not you are not just involved in the day-to-day upbringing of the child, but whether or not you are involved in the child's upbringing. So it's, I can't remember what the legal test is. Can either of you remember off the top of your head?
Significant involvement in the care of the child. It's been interpreted as care and upbringing by the case law.
Yeah, so it is a test that has to be applied. If there's there was a case a few years ago, and it kind of said how you could define significant involvement. And one of the things that they did say was it's really important about what the child's view of you is, how long you're probably going to be involved in the child's life. Now, if it's a foster carer, that would be different from maybe an aunt or a grandparent who's got that blood connection with the child. So, you know, there are ways of actually trying to test that. The reason that we want to know whether or not you're a relevant person is because you would have rights yourself then to attend the hearing, to ask for a review of the decision, to appeal the decision, to be able to go to a hearing with your own representative, to have your views heard, and also to have access to all the papers. So if you're made a relevant person in the children's hearing system, within the children's hearing system, you're on a level footing with the birth parents. So it's a really important it's an important right to have, but of course with rights come responsibilities. And it's up to the hearing, up to the chairperson of the hearing and the panel members to decide whether or not you qualify as a relevant person. It might be that they want you to come to the hearing anyway because you have the day-to-day care of the child and they want to know what's happening with the child, how they're reacting to contact, how they're getting on when they're going to school, you know, what's your commitment to the child. Children would be expected to attend children's hearings. The only reason that they wouldn't be expected to attend is if it's in particular cases where there has been sexual abuse or where you can establish that it is going to be contrary to the child's emotional or physical welfare to attend the hearing, but normally they will not want to dispense with the presence of the child if the child can attend. Things can be made easier for the child. You know, it might be possible to have them coming into the hearing separate from the parent. We have a child's advocacy worker who can speak on behalf of the child. So there are ways of making it easier for the child. For yourself attending, it's important that you understand what the options are for the children's hearing and what information you can give them, because you want to give them as much information as they require to make the decision that's going to be in the best interest of the child. So the children's hearing system is great, it works really well, but in terms of securing a child's long-term future, it's not tailored for that at all. And it means that if you still remain within the children's hearing system, you will have to have hearings at least annually. It might very well mean that the parents will ask for reviews, which they can do every 3 months. They might appeal the decisions. It means that you have to go back to hearings on a regular basis and then rake up everything that has happened in the past, and that's also there for the child. And there's always a chance that the hearing will decide, actually, we're going to vary this for the child to be returned back to their parents, because we don't believe that there's enough, that there's enough evidence for the child to need to stay where they are. So there's always an insecurity about that, and that's the reason why you might hear, the local authorities saying, look, we want you to go for a residence order, or we're going to go for a permanence order, because the children's hearing system is reactive. It reacts to a situation and it tries to sort it out, but it's not a long-term solution. So you will find that at some point they'll say, look, the children's hearing system is no longer the appropriate forum for you to be securing the child's residence with you. have your experiences been, Emma and Claire-Anne, for kinship carers who come to children's hearings?
Well, on you go, Emma, you go first.
So experience, again, a lot of them I don't think have been given much information at all from the social work department about what to expect at the hearings. A lot of them come to me, again, they don't really know if they're allowed to attend them, again, about relevant persons. I have a lot of, they don't know, are they a relevant person, aren't they not? So again, I would just encourage any sort of kinship carers on here that are going to be attending to get as much information as you can, speak to the social work department. The SCRA website actually has a lot of helpful information on it to find out more about the hearings, what happens there. They're doing a lot of like child-friendly PDFs and documents to help even like children understand what's going on there. So again, I think if they've got any questions, that there is a lot of information out there now to help them find out what to expect from a children's hearing, how to ask to become involved, how to be deemed a relevant person, and about all the potential outcomes. So I would definitely encourage to do some background information in that respect.
Thanks. Claire-Anne, do you have anything to add to that?
I know I completely agree with what Emma's saying. It's really important that if you're the carer that you try to be included in the conversation. And that may mean having to ask for relevant person status. The social worker might help you with that if you don't have a solicitor, or you may want to engage a solicitor for that aspect of it. Like you say, Rona, the children's hearing system is a short-term measure just to hold the child in situ until the long-term permanent decision can be applied for elsewhere, and that's where we go back to the permanence, adoption, kinship, or going home options. But it's really important to, I would always recommend a client gets relevant person status. It's a test that can be sometimes difficult to achieve, but in most kinship care settings you would get that, and it means you have, as you say, the right to be heard. More weight has to be given to what you say. You also have the right to appeal against the decisions that are made. So if a rogue decision was made that you think is just fundamentally flawed and not to have been made in the interest of the child, then you can appeal. And that's quite important because social work can't appeal. The reporter rarely would appeal against the decision. And the people who most commonly in Scotland appeal against decisions are the birth parents. They're not happy that their contact has been reduced or that the child's not living with them. So things can happen to your setup that really affect the most fundamental thing, and that could be the child leaving your care or the child having increased contact with a parent against your wishes. And so being relevant and having the right to appeal is fundamental to your participation in that forum.
Thanks, Claire-Anne. Just a question has come in the chat. What can I do if the person I'm caring for doesn't want to talk or see her mum, but mum isn't listening and is trying to push for contact? I'm worried as the child is known to hurt herself when very frustrated. So we don't know the age of the child, and also we don't know what order she's on. If it's a compulsory supervision order, then it would be you'd be going back to the children's hearing and they would be determining what contact is. If it's a kinship care order and it's something that has been stipulated in the KCO, then it might be a different situation. Emma, could you, just because we don't know the age of the child and we don't know the legal status of the child, can you kind of give a range of some solutions in that? And Claire-Anne, you could maybe follow up with some as well.
So, in terms of if you have an order and you're looking to vary the order, I'm just having a wee reread of the question. I wasn't listening, trying to push for contact. So if there's no so I think the gist is that there's no contact in place at the moment. Again, well, I suppose in that situation, it sounds like, well, it depends if there's contact in the order or not. If there's no contact in what's happening, then it would really be the mum would be having to take the steps to get the contact reinstated. And depending on what situation is, if it's like a children's hearing or if it's a court, then the decision makers are going to base this on what's in the child's best interest. Is contact in the child's best interest or not? From what you're saying, it doesn't sound like it, and the child, depending on the age, would be able to give their views either directly or via an advocacy worker or their own solicitor if they're slightly older as well. It's quite helpful to know about clan child law as well for children, for anyone with kinship. For kinship carers who've got older children, they can speak to a solicitor and be represented by them. So yeah, as I say, depends on the circumstances. Again, you can speak to a solicitor, speak to the social worker, find out what steps that the mum's taken. But if it's, as I say, if the child is really not looking for the contact to take place, then the decision makers ultimately have to listen to the wishes of the children and the impact that's having on, even just knowing that the mum is looking to get that, if the child has been known to hurt herself, if there's anything like that that's been going on since the child's been aware of that, make sure the decision makers are aware of all that information as well.
Okay, thanks, Emma. That's really helpful. Got a wee bit more information about the individual circumstance of this case, and it's an 8-year-old child. It's a kinship on a voluntary basis. So I take it that there isn't a kinship care order. It's just that the child is staying with the kinship care, and mum's still got parental rights and responsibilities. And that can make it tricky because the kinship carer doesn't appear to have any rights. Claire Anne, what would you do in that situation?
A range of things. First of all, I would be asking the carer to do a retrospective diary, try and compile information about when this child has been affected by, what contact has occurred, what the impact has been. The questioner, the carer is suggesting the child does not want to give views. Now, that situation is the first thing I'd want to address, because it would sound, if the child's not giving views, then there's clearly some level of trauma is accompanying this issue about mum. And so I'd want to establish, does the carer have the backup of any services at all? If social work aren't involved, then you maybe want to think about getting social work involved. Is educational psychologist at school involved? Are there any problems there? Should there be referral through the GP to CAMS, which is the Child and Adolescent Mental Health Service? You'd be wanting to get the child that help. All of those professionals would then be looking at this issue, compiling information that might help express the views of the child in an indirect way by dealing with the impact. Also, when you involve professionals who are trained to put children at their ease and to encourage them to be able to express their views, then it can help and enable children to be able to open up and to begin to share what they want. But most importantly, this person's voluntary arrangement isn't working for them at this level, because there's an inequality here where the child and therefore the carer are struggling with something as important as questions of self-harm. And so there may be a need now for this carer to look to formalise this arrangement, and I'd be recommending that they instruct a solicitor, that they think about going through the social work department. It may not suit them, and it's not for everyone that a child enter the care system through the children's hearing. I don't mean leave the carer, but go into the children's hearing system, and they might not be eligible for that system, but it may well be that they have to deal with it in the private law sense of raising an action for a kinship care order. And under that forum, the sheriff would be very interested in any information from any of those agencies who begin working now with a child. But also, the thing not to forget, if you're the carer, you're the person who knows this child best. You're the person who has this child's views at the foremost, because you're meeting that child's needs. She is the person she looks to, you're the person she looks to rather, to meet her needs. So weight will be given to what you say, weight will be given to your way of expressing her views, because she is expressing her views, even though she won't talk about it, she's telling you how she feels. It's traumatic for you and it's traumatic for her. And so I think steps have to be taken to look to formalise things, and it might well be that boundaries have to be set with mum as well. Sometimes you get birth mums who use indirect routes to communicate: Facebook, telephone, text messages, turning up at school, things that the child feels swamped by. And so the court would be interested in formalising arrangements so that there cannot be that influence brought on the child that can cause those reactions. And it may well be the court says no contact at all because of the reaction, and it's much better that some therapeutic work is done with the child than contact with mum. And the most important thing for this child is the stability of the current placement with the carer and her day-to-day life not involving trauma. Birth parent contact isn't the priority. It's something that helps a child's development and helps a situation to give a child an understanding, to give a child a relationship with a birth parent. The first thing we've got to do is look after that child's mental and physical health.
Thanks for that, Claire Anne. And we've got a bit more information about the fact that the child has lived with the paternal grandmother since she's 7 months old. I mean, I just echo what Claire Anne has said, and that is to involve professionals now, involve social work so that they have that information about what's going on. If the mum wants to remove the child from the grandmother's care, then social work can take emergency steps to prevent that from happening. And I know sometimes it's really scary because things seem to have been going okay and you can just kind of keep a lid on it. But, you know, sometimes there comes a point when you say, actually, I just can't be held hostage to whatever it is that the mum wants to do because they don't understand what's best for this child. So it's using whatever means are necessary for you to keep the child safe and for you to be able to make the decisions in relation to that child. So that's us at 4 o'clock now. I knew this would happen, that we could just talk the hind legs off a donkey. I hope you found that really helpful. I'd just like to say thanks so much to Emma and Claire Anne for sharing their expertise and their insight with us. What I will do is make sure that when we're putting together all the information from Kinship Care Week, that I have their contact details there for you, so that if any of you would seek to contact them directly, then I'm sure they'd be more than happy for you to do that. But thank you to everybody for attending, and particularly to Emma and Claire Anne for giving of your time this afternoon. I hope you found that helpful. It is a minefield, and what to take away from this is that it's different for everybody, but there is help there, and there is individual help there for you. So please don't go away feeling that you're isolated or worried about anything, because first of all, you can contact the helpline, but also you know that you can contact a solicitor if you're requiring that individual help, where you can actually instruct the solicitor and get the outcome that's going to be best for you. So thanks very much to everybody, and we've still got lots of other things going on this week in terms of Kinship Care Week, and you'll be able to see them on the website. And if there are any questions that you wanted to put and you didn't have a chance, then you know, if you phone the helpline, then they can filter it through to me, and I can deal with it if it's something that's you know, requiring that sort of level of legal input. So thanks again to everybody.